Good evening, everyone. I want to welcome you all to the Maryland State Commission on Criminal Sentencing Policies public meeting. We are happy to have you here with us. I would like to call this meeting to order. Do we have a quorum present?
Yes, we do.
Thank you. Before we start with the presentation of the background on the commission, I would like for us to go around the room and have the commissioners and everyone seated in the room introduce themselves. How many people are joining us via Zoom?
We have two commissioners that are joining us via Zoom, and then we have three individuals who are joining us for the public hearing.
Okay. I'm going to ask that the persons who are joining us virtually introduce themselves first, and then we will go around the room. Starting with you,
Judge Saunders.
Judge Saunders. Thank you.
Good afternoon. I'm Judge Michelle Saunders, and I currently sit in the District Court for Calvert County.
Thank you. And I don't know if Judge DiLeonardo is prepared to be on camera.
Okay. We know
Yeah, I'll
he's there.
introduce though. This is Judge Brian DiLeonardo, Circuit Court, Carroll County.
All right.
Thank you, Judge DiLeonardo.
Okay. And starting on my left, Senator West, do you want to introduce yourself?
Sure. State Senator Chris West, District 42, Baltimore and Carroll counties.
Thank you.
Senator Charles Sidnor, District 44, Baltimore County.
Thank you.
Matthew B. Fralin III on proxy for State Public Defender Natasha Tatik.
Thank you. Mr. Johnson.
Larry L. Johnson, at-large member.
Thank you.
Richard Gibson.
Robert Harvey, State's Attorney for Calvert County.
Thank you. Mr. Finchie.
Good evening, Richard Fincy on the Defense Bar's representation on the commission.
Thank you. Mr. Thank
Good
you.
evening, I'm Brian Johnson. I'm a professor of criminology.
Thank you.
Reno, on behalf of the Secretary.
Thank you.
Good evening, Katie Dorian. I'm here on behalf of Attorney General Anthony Brown.
Good evening, I'm Alicia Miller. I am the victim advocate representative from Harper County.
I'm Melanie Shaw. I'm a judge on the Appellate Court of Maryland.
Thank you.
Julian Caspero, graduate research assistant.
Thank you.
Good evening, Bella Nocell. I am the research assistant.
Good evening, I'm Sarah Bowles, program analyst.
Hello, Catherine Pembroke, administrative and training coordinator.
And good evening. I'm David Soule. I'm the Executive Director for the Maryland Sentencing Commission.
And we're just going around the room and introducing ourselves.
Hello, everyone. Sorry for my tardiness. My name is Sandy Bartlett. I'm a member of the House of Delegates.
Thank you, everyone, for the introductions. Now we will move on to the presentation of the background and history of the commission.
Thank you, Judge Middleton. Good evening, everyone, and welcome to the Maryland State Commission on Criminal Sentencing Policy, or Sentencing Commission, or MSCCSP, our very long acronym that we sometimes use. This is our 2025 public comments hearing. The Sentencing Commission holds an annual public comment hearing as an opportunity to solicit feedback about the sentencing guidelines and the work of the Sentencing Commission. And so we decided to start the hearing this evening by providing a brief presentation to help explain the history and purpose of the sentencing guidelines and the role of the Sentencing Commission. So starting with a brief history of the guidelines and the Sentencing Commission here in Maryland, Maryland was one of the first states nationwide to initiate a sentencing guideline system. The guidelines were first introduced by the judiciary in April 1979. The Judiciary Sentencing Guidelines Advisory Board, which is a board within the judiciary, approved a system of voluntary guidelines that was first piloted in 4 jurisdictions. Those sentencing guidelines were then approved for statewide use in the circuit court starting in 1983. And the guidelines in Maryland were in effect for 15 years with oversight by the judiciary. Then in 1999, the permanent Maryland State Commission on Criminal Sentencing Policy, which is our current body, was created with the adoption of House Bill 602 from the 1999 legislative session. The Maryland General Assembly created the Sentencing Commission as an independent agency to support fair and proportional sentencing policy and to maintain the state's voluntary sentencing guidelines for criminal cases sentenced in the circuit courts. The enabling legislation that created the current day Sentencing Commission outlined a statement of intent for the commission in Criminal Procedure Article 6-202 that includes 6 goals. 6202 states, first, that sentencing should be fair and proportional, and that sentencing policy should reduce unwarranted disparity, including any racial disparity, in sentences for criminals who have committed similar crimes and have similar criminal histories. Second, sentencing policy should help citizens to understand how long a criminal will be confined. Third, sentencing policy should preserve meaningful judicial discretion and sufficient flexibility to allow individualized sentences. Fourth, sentencing guidelines should be voluntary. Fifth, the priority for the capacity and use of correctional facilities should be for the confinement of violent and career criminals. And finally, sentencing judges in the state should be able to impose the most appropriate criminal penalties, including corrections options programs for appropriate criminals. Now, the commission has a few primary responsibilities to help address these goals. The first responsibility is to implement and maintain the state's voluntary sentencing guidelines. And this is accomplished through the second major responsibility, which includes collection and maintenance of an extensive database assembled via data submitted on the sentencing guidelines worksheets. The commission uses the guidelines data to monitor circuit court sentencing practice. The commission also examines sentencing patterns and reasons for departures for specific offense categories and within individual cell ranges to consider changes to the guidelines when necessary. Finally, the commission is responsible for providing training to criminal justice practitioners to promote the consistent application of the guidelines and accurate completion of the sentencing guidelines worksheet. The Maryland General Assembly created this commission as an independent agency to support fair sentencing policy and to maintain the state's voluntary guidelines. The Sentencing Commission was created as a balanced board of 19 members from all 3 branches of government. The commission is chaired by the wonderful Judge Dana Middleton from the Circuit Court for Baltimore City. Judge Middleton was appointed as the chair by Governor Moore on December 12, 2023. Oh, you're almost on your 2-year anniversary. Chief Justice Fader is responsible for 3 appointments to the commission. The judicial appointments are the Honorable Melanie Shaw, who is our appellate court representative, the Honorable Michelle Saunders, who's joining us virtually today, who's district court judge from Calvert County, and also the Honorable Brian D. Leonardo from the Circuit Court for Carroll County. The remaining 15 members include a cross-section of criminal justice officials, 4 members of the legislature, a criminal justice policy expert from the University of Maryland, and 2 public representatives. And appointed members serve terms of 4 years and are eligible for a reappointment. The commission aims to make sentencing guidelines policy decisions after deliberating with the many stakeholders identified here that represent a cross-section of the Maryland criminal justice system. All right, so now let's get into some of the basics, starting with what is the purpose of the sentencing guidelines. The sentencing guidelines are a mechanism to encourage proportional sentences. See that was showing. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are convicted of similar offenses with similar criminal histories are treated alike. The Maryland sentencing guidelines were designed to systematically account for the key characteristics, specifically the offender's prior record and the seriousness of the offense. The guidelines provide a baseline for judges by offering a recommended range based on the average sentence for a typical case. And finally, the guidelines help to improve transparency as they are a matter of public record. For example, the commission maintains a detailed database of offense and offender characteristics, sentence information, and reasons for departures below or above the recommended guidelines range. These data are used to inform the commission's policy decisions, and they are analyzed and used to create publications such as the commission's annual report that thoroughly describes the state's circuit court sentencing trends. So let's consider some of the basic principles of the guidelines themselves. First, the sentencing guidelines are used to inform sentencing decisions in the circuit court. Criminal Procedure Article 6-216 requires judges to consider the guidelines at sentencing. Next, the guidelines in Maryland are voluntary. This means judges may, at their discretion, depart from the sentencing guidelines when they feel a departure is warranted. The voluntary nature of the guidelines emphasizes that they are designed to be a tool to help inform the sentencing decision-making process. They are intended to complement rather than replace the judicial decision-making process. The next key component is that the guidelines are also intended to be primarily descriptive, and the guidelines are intended to be dynamic. And I will describe what I mean by descriptive and dynamic sentences. So descriptive sentencing guidelines are guidelines informed by analysis of current sentencing practices. The Maryland sentencing guidelines describe how the courts are sentencing on average for a typical case, utilizing the data that we collect via the sentencing guidelines worksheet. The descriptive nature of the guidelines means they are also not intended to be static. Rather, they are dynamic, and the guidelines may be amended when the data indicate that sentences are not consistent with the recommended guidelines range. The Sentencing Commission analyzes data collected via the guidelines worksheet and uses that data to help determine if changes to the guidelines are warranted to help better reflect current sentencing practices. Next, the staff thought it might be helpful to review what is a guidelines compliant sentence. There are a few key components that are important to understand. First, the sentencing guidelines apply only to active time and not to suspended time. And I will provide an example on the next slide to help illustrate this important point. Next, sentences to corrections options programs such as drug courts, home detention, residential treatment, work release, and a few other alternatives to incarceration are also generally guidelines compliant. And this rule allows judges to utilize a broader range of alternatives to incarceration while remaining compliant with the sentencing guidelines. Finally, sentences issued pursuant to an MSCCSP binding plea agreement are guidelines compliant. Again, that's the acronym for the sentence, the long acronym for the Sentencing Commission. The MSCCSP adopted the binding plea agreement compliance policy to acknowledge that binding plea agreements reflect the consensus of the local view of an appropriate sentence within each community. Both the corrections options and binding plea agreement compliance policies allow the court to set a guidelines compliant sentence that considers the individual community view and the specific needs of the individual. As I mentioned earlier, I wanted to provide an illustration of how the guidelines work with respect to active time and suspended time. So to illustrate this, we provided this example, these two examples. So in the first example, which would be in the yellow, highlighted in yellow, the hypothetical guidelines are 6 months to 1 year. And the defendant was sentenced to 2 years to spend all but 9 months of active incarceration. So this example, the sentence in this first example, is a guidelines compliant sentence because the active portion of the sentence, 9 months, falls within the guidelines range of 6 months to 1 year. In the second example, the hypothetical guidelines are again 6 months to 1 year. But here the defendant was sentenced to 2 years to spend all but 3 months of active incarceration. So the sentence in example 2 in the red portion of the box here is a below the guideline sentence because the active portion of the sentence, which was 3 months, is below the guidelines range of 6 months to 1 year. Next, I wanted to wrap up this presentation by highlighting some of the key select primary activities completed by the Sentencing Commission in this current year, and then some of the activities that are planned for 2026. So the first activity is an activity that we undertake every year, and that is to review and classify new and amended offenses adopted by the General Assembly. as well as the classification of any previously unclassified offenses. From time to time, we identify offenses that have not been classified. This is an important annual task, and it helps to ensure that offenses are scored consistently and fairly within the sentencing guidelines. The next activity I want to highlight is the implementation of a revised list of common sentencing guidelines departure reasons, and those were adopted effective July 1 of this year. The Commission adopted the revised common departure reasons to more closely align with the reasons reflected in the current guidelines data, to reflect input received via a survey conducted of circuit court judges at an annual conference, and finally, to provide greater insight into the circumstances of the case. The Sentencing Commission also revised the corresponding instructions that are provided in MAGs to more clearly explain why data on the departure reasons are collected. Next, in this year, the Commission also released 2 rounds of updates to the Maryland Automated Guideline System, or what we call MAGs. We had MAGs 13.0 deployed, and then an update to MAGs 13.0. Those were both significant updates. And number one, the main thing with 13.0 was updating the list of common reasons for departure from the guidelines. We also, in August of 2026, an additional new MAGs features were deployed that were aimed towards improving the overall MAGs user experience. We get feedback, as you might expect, a lot from the people that are using MAGs, and we like to show them that we're listening and incorporating things to make the application more user-friendly. The next update or activity I want to discuss is the Commission's response to legislation that was passed during the 2025 session. The Commission revised the guidelines instructions for application of the multiple victim stacking rule to clarify that each animal harmed in violation of Criminal Law Article Title 10, Subtitle 6 shall be considered a victim for the purpose of applying the rule. And then finally, at the Commission's September 9th meeting, and after a thorough review, which spanned multiple Commission meetings, this Commission voted to expand and clarify the instructions for scoring psychological victim injury, with a recognition that not all victims have access to psychological counseling or treatment. And those revisions are expected to be adopted effective January 1 of 2026. And then I'll just wrap up with a few of the primary planned activities for 2026. First, the Commission, you'll hear a little bit later about this later during the business meeting, but the Commission will continue to review the guideline scoring instructions for physical victim injury. And that's a follow-up that came on the heels of the Commission's discussion about psychological victim injury. Next, the Commission will continue to work with the Administrative Office of the Courts and their Judicial Information Systems Division to enable a feature in MDEC, which is the Maryland Electronic Court System, whereby judges and court staff will be able to create an on-demand MAGs report so that they can check the submission and status for guidelines worksheets on a regular basis when they would like to do so. As many as you now know, the Commission staff sends out a monthly report about MAGs to each county. And this on-demand feature would allow judges and court staff to run a similar type report on their own at any time of the month. And we are excited to roll that out because we've gotten multiple requests to make that feature available. And we think it will help with respect to being a more efficient process for completing and submitting worksheets. So we're hopeful that that will get deployed in 2026. And then finally, the Commission will continue to collaborate with the Department of Public Safety and Correctional Service programmers to upgrade MAGs to optimize and simplify the user experience. I do want to give out a shout out. I think I like to do that every year at these hearings, but Public Safety has been just a tremendous partner for the Sentencing Commission. We are a small agency and entity, and they help us out by hosting the application for us, MAGs for us, and their programmers have been just wonderful. We're very pleased with the team that we are working with right now, and just their responsiveness to our requests has just been tremendous. So do want to recognize that we really couldn't do MAGS on our own. So we really appreciate that. I will wrap up there. I do want to finally acknowledge those who attend the commission's public hearings, and we're about to hear from those individuals in a minute. Since the creation of the commission has always sought to incorporate feedback from both the public and criminal justice community to incorporate those into our policy decisions. And the commission values this input and wishes to ensure that the guidelines remain a relevant and useful tool for practitioners and for the public. The annual public comments hearing is just one way in which the commission solicits and incorporates this type of feedback. And we encourage anyone who has questions or comments about the guidelines or the work of the Sentencing Commission to contact us at any point via email or phone. And I've provided that information here. You can also check out the commission's website or our LinkedIn page or YouTube channel for more information. So I thank all of you for participating today. I know everyone has busy schedules, and right around the holidays can make it tougher, but we really appreciate everyone that attended either person or is participating virtually. We value your input, and we look forward to hearing it. So we'll now go ahead and start to call on our speakers. When you are called, I will just remind you that we're asking guests to please limit your comments to 5 minutes. And I will remind you if that's necessary. But I'll turn it back over to Judge Middleton to call our first guest.
All right, thank you. We're going to go a little bit out of order here since Ms. Hilliard is present. And we're going to ask that Ms. Elizabeth Hilliard, who's the Director of Government Relations for the Maryland Office of the Public Defender, to lead the speakers this evening. So thank you, Ms. Hilliard.
Thank you. Am I already unmuted? Kind of seems like it. Yeah. Okay.
You're good.
Thank you, and good evening, everyone. I'm Elizabeth Hilliard, Director of Government Relations for the Office of the Public Defender. I did submit a brief sort of memo outlining 3 pretty broad, generic recommendations that OPD wanted to highlight, not only because 2 of them are related to and an expansion upon work that the commission has already done, which we are extremely appreciative of, but also just to try and keep the conversation moving in the direction of creating a more equitable, racially aware, and just criminal system. So the first recommendation very, very respectful request that we had made is asking for participation in a comprehensive analysis, both a qualitative and quantitative analysis of the especially racial and geographic disparities that occur in Maryland's criminal legal system. So I know that the Sentencing Commission published an excellent comprehensive report in 2023 on racial disparities, but it did only cover 2018 to 2022, which I'm sure took an incredible amount of work, but it is important for us to have a broad perspective on not just 2 years, but maybe 5 years or 10 years of what sentencing disparities could look like, and with a little bit more disaggregated information on geographic breakdowns, especially even within certain districts. There are breakdowns based on the different district courts that an individual might be sentenced through, although I recognize that the original report addressed only circuit court sentences as opposed to district and circuit court recommendations or sentences. The second is, again, one that you all have already previously recommended, and we are reiterating it, bumping it up perhaps to the top of the list, working with the Department of Public Safety, specifically the Division of Parole and Probation, to help implement alternative sentencing opportunities. Your previous recommendation has included essentially a recommendation for further analysis. So we're hoping that maybe some additional analysis could be conducted on what is available, what could be made available, try and address those individuals who don't need to be necessarily sentenced to traditional incarceration, and try and connect judges with what available programs there are. And then the third piece that we addressed is reducing unnecessary pretrial detention. I think it comes as no surprise that pretrial detention often sort of takes someone's life and halts it completely, right? It throws them entirely off track. If they have a job, if they have a house, they have children, right? These are all things that can become, they might lose their job, they might lose their house, they may have their children put in the care of someone else, even within a few days or a week of pretrial detention. And so there are three kind of like sub pieces under this idea of reducing unnecessary pretrial detention. The first is the discovery rules, and I recognize that you all probably are hesitant to maybe necessarily tell the judiciary what to do, and we don't want to tell them what to do either, but perhaps together we could come together and come up with an idea of improving the way that discovery turnover is currently handled and making it more expeditious to reduce the unnecessary pretrial delays that result in unnecessary pretrial incarceration. The second piece is allowing individuals to waive their bail review. Right now, there is a second bail review that is unwaivable, a mandatory bail review. And there are plenty of individuals who would waive that given the chance, which actually would expedite the process and ideally alleviate workloads for everyone involved, not just the public defenders or the individuals facing incarceration or who are currently incarcerated. And then the third piece is reevaluating or potentially supporting changes to the current civilian complaint process. I know that last year, Delegate Addison introduced a bill to reduce the number of arrest warrants that could be issued based solely on civilian complaints, as opposed to those that are issued, of course, on the basis of law enforcement statements or other things. And we supported that. And I actually believe State's Attorney Bates also supported that. And I feel like when you have both sides sort of the system coming together and saying this may need a little bit further work, or it's not currently entirely tenable in its current iteration and its current format, we're hoping to encourage an evaluation or reevaluation and change to that as well. And that's all I have. I think I'm 1 minute over time. I apologize, but thank you guys for inviting us and allowing us to speak, and I'm happy to answer any questions. Okay.
Thank you, Ms. Hilliard. Are there any questions?
Great.
Thank you.
Thank you.
Thank you, appreciate it.
Our next speaker is Ms. Margaret Martin Berry, who I believe is joining us online.
Yes.
Thank you, Ms. Berry.
Can you take yourself off mute?
I thought I'd unmuted it. Am I there?
Yes, thank you.
Oh, great. Thank you. Thank you for this opportunity this evening to offer comments on criminal policy for your consideration as you move forward on the work of the commission that you excellently outlined tonight. Among the commission's stated goals is the increase of equity in sentencing by reducing unwarranted racial disparity. I directed my written comments to this and will add a few points this evening. The racial composition of our prisons makes clear that we are doing a poor job of reducing racial disparity. The Maryland prison population has hovered at more than 70% Black, compared to approximately 31% of Black people in the state population. As you pointed out in your July 2023 study, policing and prosecution decisions play a significant role in the racial disparities in the criminal system, and I commend the Commission for calling for study by relevant agencies. However, there are things that the commission can do and do now to affect this disparity. It can reassess offenders' score with an eye to reducing the impact of scores that exacerbate racial and ethnic differences. For example, there are a number of offenses that fall under category 3 that have had a harsher impact on people of color, such as unlawful handgun carrying. Enforcement of these laws has more to do with race and poverty and related circumstances than anything else. Similarly, weapons possession and drug offense convictions are category 3, though not necessarily involving violent action. And compare these to a drop to category 4 for wearing or carrying of a dangerous weapon with intent to kill or injure. In sum, while more study will likely be helpful, it seems that a reassessment of existing categories would help to take into account some of the policing and prosecution that leads to the current racial disparities in our prisons. I also highlight another recommendation from your recent racial disparity study. It says, examine whether disparities exist in the utilization of corrections options and other alternatives to incarceration. You know that prior research examining Pennsylvania sentences indicates that minority individuals have lower odds of receiving an alternative to incarceration. And I'm sure you'll find that the same is true here. And this should lead to greater emphasis on the use of alternatives. One correction option that should never be used for anyone is life without parole. I would like to Commission investigate why life without parole should never be used, both in terms of the harm done to the person and their family, and the ability to effectively run prisons. I would hope the Commission would then use its considerable influence to weigh in on why it should never be applied where there's any discretion, and to argue that it should be removed from our sentencing laws. Incarceration has a ripple effect. As currently administered in Maryland, it often punishes people too harshly, does not do enough to rehabilitate, and has an intergenerational impact on families. The costs are too high for failing to take more aggressive steps away from sentencing that has been and continues to be harmful. I thank you for this attention, and I thank you for the work that you do.
Thank you, Professor Berry. Does anyone have any questions? Well, thank you for joining us.
Thank you.
We will now move on to our next speaker. And I want to make sure I say the name correctly. Is it Shawnice DeBerry? Miss DeBerry?
It's Shaughnessy. How are you?
Shaughnessy. Thank you. Hi, I'm fine. Good evening. Thank you for joining us.
Thank you so much. I wanted to give you a little shout out. I see you went to Morgan State. I went to St. Augustine University in North Carolina. So HBCU pride, because we could not a couple of years ago. So shout out to all of our ancestors. I get a lot of kickback because of my political views, but at the end of the day, we are all still family. Thank you guys so much for allowing me time to speak tonight. Thank you so much for responding to my emails. It was very informative to hear the other callers. I think that what I want to lead with, I'm going to shift away from a few things. What I want to lead with is that I think that my first suggestion to this commission is you guys have a lot of people that have titles like Miss Berry and respectfully Miss Hillard, but I don't believe either one of them have ever had a mugshot. I don't believe that any of them have been rightfully or wrongfully arrested. And this is no disrespect. I hope I can be as transparent and use my First Amendment for 1 second, because I only got 5 minutes. The thing about it is that people who have had to be on the other side, whether it was right or wrong, whether they did the crime or they didn't, we are more experienced in actually having to go through this stuff from the other side. And I think that what your commission honestly lacks, in addition to your budget, in addition to qualified commissioners, and that's not for all of you guys, but a few of y'all are on my list of who put you there. The main question is, how can we create a better resolve and stop focusing on race and stop focusing on what we want to change as it relates to sentencing, when we don't even have, because your mission is about fairness, proportion, making sure everything is outlined the correct way. I have 4 different worksheets Y'all have one of my worksheets. The one worksheet you have is from 2 months after the sentencing. That worksheet is not signed. That worksheet has a more attention disorder than just about every child in class with 504 and IEP. All right. And the problem with that is that if that happened in my case, and let me just say while I'm hyping myself up, because a couple years ago, my people couldn't do this. I believe, I don't know the data on it. Y'all can go check. I'm one of the only women of color in the Anne Arundel County, home of Brady versus Maryland, that self-litigated and got a partial acquittal on my own. So on February the 21st, 2023, what I needed from the Sentencing Guidelines Commission or whatever y'all name is I needed a automatic, because I believe David does the website. I needed to get a welcome. We see that you lost one of your a part of your case. Here's Megs. Log in here so you can see what this probation agent is about to recommend for you, because this judge gave a PSI, which is wasting tax dollars, just like pretrial release and all of that other stuff. But here you can see it because you're self-litigating. Right there, understand the commission, the policy, the guidelines, maybe my due process a little bit about what was about to happen next. Because what happened next goes on everybody on the phone's tax dollars. And notice I haven't said no titles. They don't care. They don't discriminate when they start doing this stuff, right? It's just money, 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 because this industry is a cash cow. So for me, my recommendations to you guys would be to make sure that, first of all, that you get into the digital era. It's 2025. A lot of people are self-litigating. A lot of us are actually getting through this thing and we're winning it. I won't go into detail because David asked me not to, and I got to give y'all a little elevator pitch. I won't really go into detail about my case. But what I will tell you is that with 4 sentencing guidelines worksheets, one not no signature on the one that you guys have. What else is going on there? The delay in it, like, you guys need to get more feedback from everyday individuals. I would argue that Wes Moore, Anthony G. Brown, Miss Dorian, I've been emailing you since 2022. I would argue that y'all need to get out in the community and actually start getting people who have hands-on success and getting through this mess and ask us for feedback so that we can take this and say, you know what? This is what we're going to do if Miss Barry actually wants to focus on race. Because while we were on the phone, I got a text message that she held somebody for 4 months. And I don't know how true that is, but when we started talking about race, I started getting a little passionate, because people of color have worked very hard in Maryland for this stuff. And we're sitting here on here and we got the numbers allegedly, but there's a lot of stuff that's contradicting. Numbers don't lie. I come from over 20 years of tech support, telecommunications. I probably installed a lot of the services that you guys are working off of right now. When you can't tell me why 4 worksheets is this, when you can't tell me why a judge departed, when you can't tell me why a self-represented litigant does not have immediate access to that stuff, I don't want an attorney, because I don't need an attorney. I am the attorney. So because of that, I need to be able to understand my stuff so I can self-litigate. I want to make sure that I make it very clear that you guys need to get up to date with self-represented litigants. You don't have to give us legal advice. We don't need, trust me, we don't want y'all advice. What I need is to be able to see the guidelines worksheet, because, and y'all let her go over 42 seconds, so let me get mine. On February the 21st, the probation agent, because you guys keep hyping on Maryland probation and parole, who I believe, or Carolyn Schwartz, I don't believe they're here tonight. The probation agent, when I asked her why my worksheet was off and why my PSI was off, she went and put a restraining order on me. And if y'all would have had mags again, mind you, I didn't do anything to the lady, but that's just what happens when you are Black, young, and educated. And so with that being said, y'all want to talk about race, let's make sure that we are implementing stuff that's actually for real results for real people. One last thing before I get off the phone. I have 4 sentencing guidelines worksheets, and all 4 of them say unknown for whether or not I'm Hispanic or not. I don't know if somebody getting paid for that or what's going on. Como say D say, let's get some equality and due process around here. Y'all have a great one.
Thank you, Mr. Barry. We're going to move on to our final speaker for the evening, Mr. Snipes, Marcus D. Snipes, Jr. Is he present?
Yes.
Yes. Hello. Thank you for having me. Good afternoon, members of the commission. My name is Marcus Damon Snipes Jr. I am currently pursuing a writ of actual innocence, a motion for exculpatory evidence, and a motion to correct an illegal sentence as a self-represented litigant in the home of Brady v. Maryland, 1963, Anne Arundel County Circuit Court. I also have a pending arson indictment in which I am represented by counsel. These parallel cases highlight how essential it is for the commission to fulfill its statutory duties regarding sentencing guidelines data. Without going into too much detail, I only have 5 minutes. In the new indictment, the state intends to rely on my 2016 conviction, which is the same conviction under review in my writ of innocence. To defend myself in the present case and properly litigate the writ, I must be able to verify how my 2016 sentence was scored under Maryland's voluntary guidelines and whether those calculations were even accurate. Under Criminal Procedure 6-208 and 6-210, the Commission is required to collect and maintain sentencing guideline worksheets, monitor circuit court sentencing practices, and maintain a sentencing database to ensure fairness, consistency, and compliance across the state. These duties are also reflected in COMAR guidance and in the Commission's own public mission statement. When I requested clarification regarding my worksheet last week, Dr. David Soule, the executive director of the commission, responded to me and reply alled, even though a Baltimore Sun editor covering my pending arson case was copied on the email. Dr. Soule stated that my sentence was not a guidelines departure and that the commission does not have the authority to oversee individual cases. I respect those limitations. I do. The commission does not have that authority, but the commission does have the authority and statutory obligation to maintain accurate sentencing data and that defendants must rely on when their liberty is at stake. Shortly after, Ms. Catherine Pembroke informed me that the commission destroys older worksheets older than 7 years. Because my case was sentenced in 2016, she stated that the worksheet had been destroyed. Yet, she also stated that the image I submitted matches what is entered in the commission's database. I respectfully ask how a comparison can be made to the worksheet the commission says no longer exists and what specific COMAR and statutory authority authorizes destruction of sentencing records essential to innocence and post-conviction review. These issues aren't personal, guys. They're structural. I got 3 questions for you, Commission. How does the Commission publish sentencing trend data spanning more than 2 decades if worksheets are destroyed after only 7 years? In the circuit court, if the circuit court clerk retains the official worksheet, but the Commission destroys its copy, how can defendants verify guideline scoring or identify sentencing errors? What safeguards exist when the state relies on a prior conviction currently challenged for innocence to increase exposure in a new case? Now listen, I'm not asking you to intervene in any of my proceedings. Like I said, I'm most of the time self-litigated. But what I'm asking for is clarity, transparency, and to adhere to the statutory data maintenance obligations so that Marylanders, whether represented or self-represented, can rely on the accuracy and integrity of the sentencing guidelines system that this commission oversees under law. Thank you for your time and your consideration. Y'all have a blessed day.
Thank you, Mr. Snipes. Is there any questions? Are there any questions? Well, thank you all for joining us this evening, and thank you for submitting I'm gonna say your information or summaries of what you were going to talk about beforehand. We do appreciate your input. Thank you. At this time, that's going to conclude the public session of our meeting. We will now go into the business session.